Hey out there, legal warriors. In this video, I'm going to cover the mistakes that can destroy your DUI case. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. And more importantly, more people get the help they need. Now I'm just going to jump right into it. DUI is one of the most common charges that gets charged in Washington state, and no one should be out there driving after consuming alcohol, but let's face it, alcohol is everywhere, right? It's the one type of thing that we have to explain if we're not drinking. You're not drinking? Why? And of course, even though Uber and Lyft and other ride programs are out there, I mean, there's even driverless cars in some cities now are out there, still so many of us can make the mistake of deciding that we are okay to drive when we're not. And so in this video, I'm going to cover some big mistakes that can destroy your DUI case. So let's start from the beginning. Let's start from the traffic stop. What's the first biggest mistake that can destroy your DUI defense case? It's doing the field sobriety tests. The field sobriety tests are ancient and they are subjective, and it is not possible, in my opinion, for any subject, someone who stopped for investigation of DUI, to pass that test, because there's nothing in it for law enforcement to say that you pass the test. Think about it. If you pass the test and the officer says you passed the test, now their arrest is toast, right? Hey, they passed the test, but I knew better. I arrested them for DUI anyway. And that's going to get tossed then. So as we talk about field sobriety tests, what are the three standardized field sobriety tests all throughout the United States? First is a horizontal gaze nystagmus test. Follow my finger with your eyes and just your eyes. And that test is really only validated for consumption of alcohol, not for being over the limit, though the prosecutors will tell you different. The second test is the walk and turn. That's a set of 8 instructions where you're supposed to take 9 heel-to-toe steps down a line, turn in a certain way, and take 9 heel-to-toe steps back. And guess what? They score you if you step off the line, and almost always there is no line. It's an imaginary line. How you step off an imaginary line? Ask the prosecutor. And then finally, the third field sobriety test is the one-leg stand test. If they're ever going to say you passed one, it'd be this test. It's standing on one leg, counting out loud, 1001, 1002, and so forth until they tell you to stop. Still, bogus test, but don't destroy your DUI defense case by doing those field sobriety tests. At least if you're in Washington state, there's no consequence to you not doing the test. If you're watching this from another state, you've got to take a look at what YouTube's putting out there. But in some states, there could be some penalties for not doing a field sobriety test. I can't speak to any other states, but in Washington, you are not required to do them. So that's the first way that you can destroy your DUI defense case. The second way, let's move on to you've been arrested and now you're at the police station, right? I think the second way you can destroy your case is by talking too much to the police once you're under arrest. They want to ask you a set of 32 standardized questions. And it's just on this form that they fill out. Every DUI case is the same. And those questions aren't designed like, what's your name and address? Those questions are designed to cut off every single one of your defenses. They're going to ask you questions like, how many hours of sleep did you have last night? Well, they want to try to cut off your defense of just saying you were tired, right? If you say you had 8 hours sleep, you must not have been tired. Are you under the care of a doctor or dentist? That's an actual question that everyone gets asked if you agree to answer these questions. Most people will say, no, I'm not under the care of one. You're not going to mention your doctor and have them call them. Well, if you say you're not under the care of a doctor or dentist, when you later claim that you couldn't do the field test because you got a back injury or a knee injury or something else that's wrong, well, that must be a lie now because you said you went under the care of a doctor, right? Without looking, what time do you think it is? I mean, do we all keep an exact time in our head, right, especially under this type of thing? Well, if you say it's 2 a.m. and it's really 4 a.m., must not be because you're nervous, must be because you were drunk, right? So if you answer those DUI interview questions, you cannot help yourself. It is helping destroy your DUI defense. Now let's move on. Now we're at the court procedure. We're in the court process where we're basically fighting the DUI case in court. How can we destroy our defense there? Well, the biggest way we can destroy our defense is consuming alcohol and getting into another problem while the case is going on. If we don't obey conditions of release, which is usually don't drive without a license and insurance, don't consume alcohol while the case is going on, and of course don't have any new crimes, if any one of those things happens and the court or prosecutor find out about that, any amount of discretion that your attorney was going to get on your behalf fighting for you is much harder to get now because you've already shown the court or the prosecutor that you are not a good risk, right? I told you not to drive without a license and insurance, but you drove on a period of suspension. Well, now we have a reason to punish you more. Hey, I told you not to drink, and when you went in for your alcohol evaluation, they took a UA and it came back with alcohol in your system. You're not obeying the court. You must be alcoholic. You can't quit drinking. Or God forbid, you got another crime. If you get another crime, they're not just going to be mad. They're going to put you right in jail for violating that condition of release. So we cannot have you have any type of problem while the case is going on. I think those are three main ways that you can destroy your DUI defense. If I wanted to throw in a bonus, and why not throw in a bonus? The fourth way that I can see that we destroy our DUI defense is not doing what your attorney tells you to do. Please do what your attorney tells you to do. Have some faith in your attorney. They know what they're doing. There's going to be all types of things that we might need you to do to help your case. We're going to need to have you do an alcohol and drug evaluation to show you don't have a problem. We're going to need you to do an alcohol and drug information school. We're going to need you to do a DUI victims panel. We're going to need you to tell us things about your life, right? Because the DUI is one of the few cases where they've got a professional witness. They have multiple professional witnesses. They've got the officer who pulled you over, or officers. They've got the state toxicologist who's going to swear the machine was operating properly, and they've got the people that work in the state toxicologist lab in case you have a blood draw, marijuana, stuff like that. They have all these people the prosecutor can rely on to show up and testify that you screwed up. They're not going to say otherwise. That's not why they're called to court. So we need you to stay out of trouble. We need you to tell us about what life issues got us into this situation. There's never an excuse, but there's usually an explanation. And we might need you to do community service. We might need you to do something so we can take advantage of the prosecutor's huge caseload and any problems we can find in your case to get them to offer you discretion. Remember, when a prosecutor offers you discretion, a reduction in a DUI, it's almost never about the case. It's about the prosecutor's caseload. They can only do so many cases, and so we need to maneuver you where you're the person who gets the discretion. You're the person who gets the second chance. And if you avoid all these things that can destroy your DUI defense, you're much more likely to come out with that outcome that you need and you deserve. So I hope you found that useful. If so, please like and please subscribe. More people see it. More people get the help they need. More importantly, if you got a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this for more than 20 years, 25 years next week. And if we get on board, we'll listen to what happened, we'll identify a way forward. We will be there for you. Thank you.